Hi, everyone. We're here for the second webinar of the 2019 EU Law and Sustainable Development webinar series. Together with me, Professor Riccardo Pavoni, the academic coordinator of the EU Law and Sustainable Development module, hosted by the University of Siena, and our guest, Professor Gabriela Oanta from the University of A Coruña in Spain, Associate Professor of Public International Law there, Director of its University Institute for European Studies, and one of European great experts on international law of the sea, the EU Common Fisheries Policy, and sustainable development issues. We are very glad to be here with her, and I will just now give the floor to Professor Pavoni for a short introduction of this webinar. As usual, we will have a presentation and then a space for questions and comments afterwards. Professor Pavoni.
Yes, we are delighted to have Gabriela Oanta with us today. For us, as Dario Piselli has just said, this is the second webinar of our Jean Monnet module. With respect to Gabriela, I would like to just recall what Dario has said, that Gabriela is a professor of international law and international relations at the University of A Coruña in Spain, and that she's also the director of the local University Institute of European Studies, the Institute Salvador de Madariaga. And what I want to stress is that this is, for us, is supposed to be a best practice when it comes to coordination and collaboration with other Jean Monnet holders, fund holders, because Gabriela Oanta is the academic coordinator of a Jean Monnet module in her university, which is devoted to the European Union's integrated maritime policy. I'm particularly glad to have Gabriela with us. She's also a friend, a colleague that we usually collaborate with, and she's an expert on maritime issues, on maritime legal and policy issues, with a focus on the EU Common Fisheries Policies. She has published extensively in these areas. I would just like to recall a recent book by Gabriela on the law of the sea and the rights of vulnerable persons, which is a book that I recently read, and it's very interesting. So we are particularly honored to have an expert with us, which can tell us more about the European Union's approach to the implementation of SDG 14 on life below water, so the conservation of fisheries and the management of sustainable fisheries. And so I think this is just the time to give the floor to Gabriela for her webinar. Thanks for being with us, and the floor is yours, Gabriela.
Absolutely. Just 1 second for me to share the screen so that Professor Oanta can share the presentation. There you go. Now you should have the presenter's role.
Okay, thank you very much. Good afternoon to everyone. Thank you, Professor Pavoni. Thank you, Dario, for inviting me to be part of the webinar series that we are in charge with in the framework of the European, of the Jean Monnet module. You are the holder at the University of Siena, and I'm very glad, I'm very honored to be part of this project. It is an honor, of course, to talk in the framework of this series. I'm very glad that Professor Pavoni has given me this opportunity, and as he just mentioned, it is a new manifestation of our collaboration and joint activities now in the framework of Jean Monnet actions. This year, as we know, 30 years, 30 years ago, Jean Monnet actions have been created. In my opinion, they have been a real success for the European Union, as the Erasmus project has been in relation to students. So, the topic of my intervention, the title of my intervention is the European Union and Sustainable Fisheries Partnership Agreement. I would like to thank Professor Pavoni and Dario as well for their kind words regarding my research field in relation to the law of the sea, common fisheries policies, and so on. So thank you very much. I will try to share with you the PowerPoint presentation I have prepared for my intervention. I think it would be easier for everyone to see the main ideas of my intervention. I hope it will work. Just a moment, please. Yes. Now, if I'm able to do it, let's see. Could you tell me, please, if everything is all right? Are you able to see my slide, please?
Yes, it's working well.
Yes.
Okay, so as I have just mentioned, the title of my intervention is the European Union and Sustainable Fisheries Partnership Agreement. During my intervention, I will try to focus on three main issues. Firstly, I will talk very briefly on the European Union and the seas and oceans. Secondly, I will refer to the European Union external dimension as a framework of its common fisheries policy. And thirdly, I will focus on the Sustainable Fisheries Partnership Agreement. In this regard, in relation with this main topic of my intervention, actually, I will start with basic considerations regarding this agreement. After that, I will refer to their legal basis, and I will finish my intervention with the examples of sustainable fisheries partnership agreements already signed by the European Union. Some of them, of course, are still in force. Some of them are dormant. And I will try to give an overview of these agreements. Well, the European Union, as we know, is surrounded by numerous islands, 4 seas and 2 oceans. Europe is a peninsula, so it's maritime issues and all the aspects related to the seas and oceans are quite relevant for this international organization. For example, the European Union coast is larger than the one of the United States and of Russia. More than 2/3 of the European Union borders are maritime. But when we refer to the European Union coast, we have to take into account that the European Union, that a few of its member states have areas that are in the Indian Ocean and in the Caribbean Sea. We know these regions as the outermost regions. So the European Union has a very relevant presence on the international stage in relation to the seas and oceans. For the European citizens, furthermore, seas and oceans are very relevant, as no European citizen lives more than 700 kilometers far from the coast, and almost half of the EU population lives less than 50 kilometers far from the coast. Therefore, the European Union has lots of maritime interests. They are very diverse and affected as a whole. All these issues are quite relevant if we want to refer to the European Union as one of the main international actors. In this field, in relation to the seas and oceans, undoubtedly the European Union is an active actor and generally speaking is an active actor in relation to the marine environment as well. The European Union has been a very important actor for the transformation of the international law of the sea. As it is known, it is an international organization and it has legal international personality nowadays, according to Article 47 of the Treaty on the European Union. But at the same time, the European Union is quite conditioned by the principle of confer. Thus, according to Article 5, Paragraph 2 of the Treaty of on the European Union is entitled to do only what its member state wanted for it to do. At the same time, as I have just mentioned, the European Union is one of the most important coastal entities, and it has one of the largest long-distance fleet. Therefore, fishing activities, fish stocks are issues that are quite relevant for the European Union activity as a whole. But as we know, fishing stocks are quite limited nowadays. It's the European Union waters which are under the sovereignty or jurisdiction of the European Union member states have their own fish stocks, but they are not enough for the European consumers. Therefore, the European Union has to fish in other seas and oceans. It is quite relevant to mention that almost 25% of the European Union fishing captures are in water that are not under the EU jurisdiction. Approximately 8% of the EU fishing captures are due to fisheries agreements with third countries, and the 20% of the EU fishing captures are doing in the high seas, basically in areas where regional fisheries management organization exists. We have to take into account as well that the European Union is the first fish market in the world, and it is the third fishing power globally, having an important transformer sector of fishing. So the European Union is quite conditioned by the situation of the seas and oceans, by the environmental status of those seas and ocean, where its fishing fleet is developing its activity. After the adoption of the 1982 United Nations Convention on the Law of the Sea, a new marine area appeared on the international stage. Nowadays, under current international law, the economic exclusive zones are very relevant for the European Union activity in the field of fishing. Why? Well, the answer is quite easy. 90% of the fishing resources globally are in the EEZs of developing countries. This situation is very much conditioned by different provisions of the United Nations Convention on the Law of the Sea. In the following minutes, I will refer to three articles of this international treaty that condition in some way or another the general framework of international fisheries agreements signed by the European Union with third countries. For example, Article 56, Paragraph 1 of the UNCLOS, the United Nations Convention on the Law of the Sea, is that the coastal state has sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or not living, of the waters subjacent to the seabed and of the seabed and its subsoil. Furthermore, Article 61 of the same convention, the coastal state shall determine the allowable catch of the living resources in its exclusive economic zone. And in addition, Article 62, Paragraph 1 of the UNCLOS contains the obligation for the coastal state to promote the objective of optimum utilization of the living resources in its EEZ without prejudice to the Article 61 I have just mentioned. In addition, Article 62, Paragraph 2, the coastal state has the obligation to determine its capacity to harvest the living resources of the EEZ. Where the coastal state does not have the capacity to harvest the entire allowable catch, it shall, through agreement, and this is very important under my view, or other arrangement, and pursuant to the terms, conditions, laws, and regulations refers to in other paragraph, give other states access to the surplus of the allowable catch. It is precisely in relation to this possibility that coastal states have in the field of fishery where the European Union is able to sign international fisheries agreements. In order to understand better the international fisheries agreement that the European Union is entitled to sign with third countries, it is important to understand the limit and some aspect of the external dimension of the European Union common fisheries policy. While the European Union, since the 70s, above all, has a policy entitled Common Fisheries Policy that contain all the legal requirements for the European Union in order to sign international fisheries treaties. This common fisheries policy started in the field of agreement, international agreements. That's the main issue of my intervention. Well, starting in November 1976, the European Union has a community fishing zone of 200 maritime miles in its North Atlantic coast and in the North Sea. Well, since then, the exploitation of the fisheries resources in this area by third countries' fishermen shall be governed by fisheries agreements signed between the European Union or the economic or the EC at that time and the third countries concerned. Of course, this was decided in 1976, but in the last 40 years, more or less, the provision adopted by the Council in November 1976 has been completed by other provision provided by the European Union primary law as well by the European Union secondary law. For example, according to Article 3, Paragraph 1, letter D of the Treaty on the Functioning of the European Union, this international organization has exclusive competence only in relation to the conservation of marine biological resources under its policy. In addition, Article 4, Paragraph 2, letter D of the Treaty on the Functioning of the European Union has shared competence with the member states in the field of agriculture and fisheries, excluding the conservation of marine biological resources, where, of course, the European Union has exclusive competence, as I have just mentioned. In addition, Part 3, Articles 38 to 42 on the Treaty on the Functioning of the European Union, the Treaty on the Functioning of the European Union refers to fisheries together with agriculture. So the EU primary law contains some limit to the European Union activity on the international stage in relation to fisheries. Moreover, the European Union secondary law contains a lot of regulations regarding common fisheries policy that refer to external dimension of the European Union in this field. I will refer in the following minutes only to Regulation 1380 adopted in 2013, which is the framework or regulation on common fisheries policy. The other ones complete this main regulation, and of course there are many other regulations that refer to fisheries and particularly to international fisheries agreements, as I will explain to you in the following minutes. So just to see where fisheries agreements signed by the European Union with third countries find, I would like to mention you that the main manifestations of the European Union external fisheries policy refer to four main aspects. First, the fisheries agreement signed with third countries. Second, the European Union relations with different regional fisheries management organizations for the fishing activities into the high seas. Third, the fight against IUU fishing. And fourth, the adoption of new norms of international law of the sea, as nowadays there is an international conference developing its work in the framework of the United Nations relation with marine biodiversity in areas beyond national jurisdictions of state. But focusing me in the following minutes on the Sustainable Fisheries Partnership Agreement, I would like to mention from the very beginning that there are two kinds of international agreements that exist in the field of fisheries. On the one hand, public access agreements or international fisheries agreements or sustainable fisheries partnership agreements refer to those access agreements concluded between the European Union on behalf of its member or with third state. And on the other hand, we have private access agreements. That means access agreement concluded between private companies based in the European Union member states and third states. I will refer only to public access agreements. Those agreements that are signed by the European Union with third countries in order to have access to the EEZ of those third countries. In relation to public access agreements, we have to take into account that there are two kinds of agreements. Again, on the one side, we have Northern agreement, and on the other side, we had sustainable partnerships, fisheries partnerships agreement. The Northern agreement are those agreements signed by the European Union with Norway, Iceland, and Faroe Islands, which are joint management fisheries of shared stocks. And on the other hand, Sustainable Fisheries Partnerships Agreement refer to bilateral fisheries agreements consisting of financial and technical support in exchange for fishing rights in the EEZ of partner countries. So if we want to be very precisely, we have to take into account that the Sustainable Fisheries Partnership Agreements refers only to these bilateral fisheries agreements signed by the European Union with third countries. Just to give you a few ideas on this partnerships agreement, I would like to mention you that according to this agreement, the European Union gives financial and technical support in exchange for fishing rights, generally with developing countries. The only exception is with Greenland, actually. They give priority to local artisanal fleets. They protect endangered species, banning discards and targeting surplus productivity only. And this is very important, these agreements are restricted only to agreed target species. Well, if we take into account this later consideration, I can divide the Sustainable Fisheries Partnership Agreement into two main categories. The first category refers only to tuna agreements, and the second category refers to mixed agreements. So depending on the case, we will have tuna agreements or we'll have mixed agreements in the field of fisheries. Just to refer to the legal basis of the Sustainable Fisheries Sustainable Fisheries Partnership Agreement, I would like to mention, to stress that these agreements are international treaties signed by the European Union and a third country. According to this, to such an agreement, the third country authorizes the EU fishing vessels to fish into its waters, and such an agreement will be made up by three parts. There is a framework agreement signed between both parties. There is a protocols where specific financial technical conditions are included, and they are complemented by an annex that refer to a specific aspect and develops more in details the framework agreement and the protocols provisions. All these aspects are included in the annex. Well, it is very relevant, under my view, to mention the exclusivity clause that European fishermen have when they are fishing, they are doing their activities in waters that are not under the jurisdiction or sovereignty of the European Union member states. But there is a case of the European Court of Justice from Luxembourg, published in October 2014. It was a judgment provided in relation to a request for a preliminary ruling presented by a Swedish court. And according to this judgment, the Fisheries Partnership Agreement must be interpreted as excluding any possibility for community vessels to carry out fishing activities in Moroccan fishing zones. It was about the Fisheries Partnership Agreement signed with Morocco at that time, on the basis of a license issued by the Moroccan authorities without the intervention of the competent European Union authorities. This means that if the European Union has signed a sustainable fisheries partnership agreement with a third country, no other EU vessel is able to sign a private access agreement with Moroccan or with a third country. Always the European Union fishermen will be conditioned by the terms of the Sustainable Fisheries Partnership Agreement signed by the European Union. In order to understand better what a Sustainable Fisheries Partnership Agreement means nowadays under the current Common Fisheries Policy legal basis, I would like to mention you that there are three articles from the regulation number 1380 adopted in 2013, namely Article 4, Paragraph 1, Paragraph 37, which provide us a definition of such an agreement. Article 31 refers to principles and objectives applied to this agreement, and finally Article 32 refers to financial assistance. Of course, this definition provided by Article 4, Paragraph 1 is relevant in order to understand how international fisheries agreements, as well known till 2013, have transformed to exploit in a sustainable way fishing stock. For example, according to this article, a Sustainable Fisheries Partnership Agreement means an international agreement concluded with a third state for the purpose of obtaining access to waters and resources in order to sustainably exploit a share of the surplus of marine biological resources in exchange for financial compensation from the Union, which may include sectorial support. Of course, they are detailed. There are 10 paragraphs in this Article 31 regarding principles and objectives. Sustainability is mentioned several times. I will pass through all these provisions. And finally, the Article 32 refers to financial assistance, and this is highly topical issues because when the last reform of the Common Fisheries Policy was adopted, it was a large debate on if these fisheries agreements still have to be part of the Common Fisheries Policy, or if they should be a part of the European Union Cooperation for Development policy. I think under my view, these fisheries agreements have to be a part of the common fisheries policy. Is what it happens nowadays. Let's see in the future what decision will be adopted by the European Union. Taking into account all these aspects, all these legal provisions, we have to ask ourselves if there is a real surplus of fishing stocks at international level in order to offer the EU fishing fleet the possibility to catch the fish stocks. As I mentioned a few minutes ago, only catch surplus not needed by the local population and identified surplus by means of best scientific advice and of the relevant information exchanged between the Union and the third country about the total fishing effort on the affected stock by all fleets are allowed. According to this Sustainable Fisheries Partnership Agreement, the European Union is entitled to sign such agreement only with democratic states. This is a very sensitive issue. In order to preserve its opinion, the European Union decided to introduce a clause concerning respect for democratic principles and human rights by the third country, which constitutes an essential element of such agreement. Of course, again, if we look at the fisheries agreement signed with Morocco, well, these issues are very sensitive. Undoubtedly, under my view, there are lots of benefits of this fisheries agreement. Under my view, they promote sustainable fisheries because there is a bilateral joint scientific committee established according to such an agreement. Only surplus stocks could be fish and so on. These agreements reinforce transparency, encourage partnership, they fight against illegal fishing, ensure equal rules, they create legal certainty for the EU fleet operators, and of course for partner countries. These agreements are quite relevant. Here we have a map with the Sustainable Fisheries Partnership Agreement as we know them nowadays since 2013. We have this map, for me is very visual, in order to see the number of the international fisheries agreements signed by the European community at that time in the 80s. We have in red all the fishing agreements signed at that time. In yellow, we have the fishing agreement signed in 90s. And now in green, we can see the agreement signed since 2000 forward. So we can see that the fishing interests for the European Union have changed in the last 30, 40 years, more or less. Nowadays, I will provide you some information regarding the situation of the international fisheries agreement. So we can see there are lots of fisheries agreements signed by the European Union with above all developing countries. Some of them are dormant, they are not enforced anymore, or a new agreement a new protocol is negotiated, and the most part of them are still in force. In the following two, in the next two slides, I will give you the information regarding the situation of this agreement nowadays. For example, the European Union has around 10 fisheries agreements in force nowadays. In the case of Cabo Verde, a new protocol is negotiating nowadays, and the legislative procedures are underway. In the case of Comoros, the agreement was denounced, and the protocol expired in 2016. I think that in the following months, it will not be possible for the European Union to have a new agreement and a new protocol. The agreement with Cook Island is in force. The same with Côte d'Ivoire. Actually, it was adopted. It was published by the official journal of the European Union a few months ago. The protocol with Gabon expired in July 2016, and no negotiations are taking place nowadays. With Greenland exists such an agreement. With Guinea-Bissau, a new protocol is negotiated and legislative procedures are underway. For example, a few days ago, this month, the European Commission published a communication, a proposal for regulation in relation to the agreement with Guinea-Bissau. In the case of Kiribati, the protocol is not in force nowadays. The same with Madagascar and Micronesia, Mozambique, Sao Tome and Principe, and Solomon Islands. In the case of Mauritania and Mauritius, the agreements are in force. Senegal and Seychelles are in the same situation, and in the case of Gambia and Guinea, Equatorial Guinea, a new agreement and protocol are negotiated. But I would like to, in the following, taking all this information, I would like to focus in the following minutes very, very briefly to the fisheries agreement signed by the European Union with Morocco. As I'm living in Spain, I realize how important this agreement is for Spanish fishermen, especially from Andalusia. Well, here we have an agreement. Well, we have the relation of the Northern Agreement signed as well, but they are not in force nowadays with Faroe Islands, Iceland, and Norway, as I mentioned a few minutes ago. Well, very briefly, a few words about the agreement, the fishery agreement signed by the European Union with Morocco. Well, in the case of Morocco, we know that there is a legal problem with the international status of Western Sahara under international law. Of course, Morocco and Spain don't share the same opinion on the legal status of Western Sahara. The European Union has the same position as Spain. I will not focus on the legal status of Western Sahara under international law. Just I will refer only, I will make some consideration in relation to fisheries aspects, because it's a very controversial issue. Well, the first agreement signed by the European Union with Morocco was signed in 1995, and since then new agreements and new protocols were negotiated. For example, a protocol adopted in 2013 has presented political problems, and finally in July 2014, well, Morocco decided to ratify the protocol, but in the meantime, there was a case, well, there were several cases before the Court of Justice of the European Union in relation to Western Sahara and the water adjacent to its coast. Just to mention you, because it is the most relevant case in relation to fisheries, well, in February 2018, the Court of Justice of the European Union provided its judgment in the case Western Sahara campaign. It was a preliminary ruling concerning the validity of the Fisheries Partnership Agreement signed by the European Union with Morocco in 2006, and also to the protocol in force from 2013 to 2017. The Court of Justice from Luxembourg considered that both texts were not applicable to the waters adjacent to the territory of Western Sahara, and the most important waters for fisheries interest are not in the north part of Morocco, but in the water that would correspond to Western Sahara. So Western Sahara, under international law, is not a part of Morocco. Of course, Morocco affirms it is a part of its territory. So this judgment of the Court of Justice of the European Union has caused a lot of political problems, diplomatic disputes, I may say, and finally both parts were able to negotiate the text of a sustainable fisheries partnership agreement in this case. In July 2018, such an agreement was signed by both parties, but after that, the ratification procedure has started both in the framework of the European Union and in Morocco. And finally, last month, in March 2019, the European Union published in its official journal this agreement. It's very important with this, and I will finish my intervention with these considerations. In relation to Western Sahara, well, this new agreement had to take into account the Court of Justice judgment in February 2018. So is for this that an article was included into the Sustainable Fisheries Partnership Agreement that refers specifically to the fishing zone in order to know where the European Union fishing boats are entitled to fish and where not. And at the end of the Sustainable Fisheries Partnership Agreement, an exchange of letters between both parties was introduced. Just to resume a lot, the new Sustainable Fisheries Partnership Agreement refers to the waters of Western Sahara as well. But this doesn't mean that the European Union recognizes that Western Sahara is part of Morocco. Why? Because because the exchange of letters signed by both parties on 14th January this year, both parts affirmed that they respect the Court of Justice judgment of 2018 on the adjacent waters of Western Sahara, which are not under the Morocco sovereignty. And this exchange of letter mentions that the fishery agreement is concluded without prejudice to the parties' respective positions. For example, the European Union doesn't recognize the Morocco sovereignty on the Western Sahara, and Morocco affirms that the Sahara region is an integral part of the national territory over which it exercises full sovereignty in the same manner as for the rest of the national territory. Morocco considered that any solution to this regional dispute should be based on its autonomy initiative. Morocco stipulated its position. The European Union did the same. The important issue here is that the European Union fishing fleet are developing their activity in Morocco and in the adjacent waters of Western Sahara, according to the provisions of the Sustainable Fisheries Agreement that has just been published by the official journal of the European Union, and of course taking into account the sustainability considerations in the field of fisheries. These are the basic ideas I wanted to mention in relation to the European Union Sustainable Fisheries Partnership Agreement. Thank you very much, grazie mille, and I'm at your disposal for any consideration, any question should you want to make me. Thank you very much.
Thank you very much, Professor Oanta. We are now back. I've seen that we have a question from the chat, but maybe first, if Professor Pavoni, if you want to intervene and follow up.
Yes, of course. Thank you.
Well, no. First of all, just to thank Professor Oanta for her webinar. I think she gave a very comprehensive overview of the importance of this, of the external action of the European Union in the field of sustainable fisheries, the conservation of oceans, etc. And she underlined very well how important are these sustainable fisheries partnership agreements in that context. I just have a curiosity rather than a broad intervention. I would like to make to ask a question, to ask Gabriela a question about the last part. I'm very much interested in the controversy between Morocco and the European Union regarding the territories of Western Sahara. I've read, I've commented on the judgments of the European Union regarding Front Polisario and the latest judgment on Western Sahara campaign. So, but I see that the issue, as you put it, is not finally settled, because this sustainable fisheries agreement with Morocco actually applies to the territory of Western Sahara, but then we have this exchange of letters where they say that we respect the Court of Justice judgment. So how come? What does this mean? To me, it does not mean anything. I mean, will they respect or not that judgment? Because the wording of the agreement is pretty clear. It does apply to Western Sahara. So I don't understand this. How they thought they would solve this problem.
Yeah. Well, thank you very much for your kind considerations. I hope that Morocco issues, Morocco issues, how to say, well, they're very sensitive, and I'm living in Spain, and I know how important this fishery agreement is for Spanish fishermen. Yes, it's very controversial issue. I have been surprised, for example, with Front Polisario against the Council and Council against Front Polisario, both judgment. I was quite surprised because at the very beginning in 2014, when Front Polisario brought the action before the Court of Justice of the European Union, I thought that the Court of Justice would say that it didn't have jurisdiction in order to, because Front Polisario didn't have active legitimation in order to bring such an action before the Court of Justice from Luxembourg. But finally, they accepted. It was a very interesting judgment under my view, because it made different considerations in relation to the United Nations Convention on the Law of the Sea, not only in relation to common fisheries policy. And a few months later, the Council introduced an action against that decision. And finally, the main argument, the previous judgment was annulled, basically. And finally, we, in 2016, I think, Western Campaign decided to introduce the action before, it was a preliminary ruling presented by the UK court before the Court of Justice. And I like very much the opinion of the General Advocate in this case, but the decision, the judgment was quite different. And for me, I think that the Court of Justice could focus more on the problem of Western Sahara, and it contains only general references that if we are doing law of the sea or common fisheries policy or international, generally speaking, it's nothing new in relation to this position. And finally, when I wanted to see the Sustainable Fisheries Partnership Agreement, and I was very happy that at the end of March, the European Union finally published its Sustainable Fisheries. And I wanted to see the problem of Western Sahara, or the issue of Western Sahara, how it has been resolved. Because the Council and the European Parliament had to take into account the decision of the Court of Justice of the European Union. It is not possible to negotiate a new agreement without taking into account the case law of the Court of Justice from Luxembourg. So the definition contained by Article 1, paragraph H, refers in technical reasons, parallels 35 degrees, 47 minutes, and so on. And mentions that this definition shall not affect any negotiations on the delimitation of the sea areas of coastal states bordering the fishing zone or the rights of third countries in general. And at the end, we have the exchange of letters that was signed by both parties on 14th of January this year. And if we look at the letter from the Union, there is a reference to this situation that stipulates the fisheries agreement is concluded without prejudice to the parties' respective positions. For the European Union, references in the fisheries agreement to Moroccan laws and regulations are without prejudice to its position concerning the status of the non-self-governing territory of Western Sahara, whose adjacent waters are part of the fishing zone defined in point H of Article 1 of the Fisheries Agreement, and its right to self-determination. So, under my view, the European Union doesn't recognize that Western Sahara belongs to or is under the sovereignty of Morocco. It still recognizes the right for Western Sahara to self-determination. And it gives the floor to Spain, if I may say, to find a solution to negotiate with Morocco the maritime delimitation of their waters in the Mediterranean Sea and the Atlantic Ocean, because they are both parts.
The Canary Islands, yeah.
Yeah, so the European Union doesn't formally or legally recognize that Western Sahara is part of the territory of Morocco, but at the same time, the European Union needs the fish stocks. And it's like, well, I don't recognize that Western Sahara is part of Morocco, but I recognize that Morocco is entitled to manage in some way the fishing activity in the waters of Western Sahara. So it's like a compromise solution in order to give access for EU fishing vessels to go there, to fish, developing their activity and so on. This affects, of course, Spain a lot, but there are many other countries. There are around 10 EU, I don't remember the exact number, of EU member states which are entitled to have access to fishing possibility into the waters of Western Sahara. So I think that from a sustainable point of view of fisheries stock, it is a very good thing that the Sustainable Fisheries Partnership Agreement has been signed between the European Union and Morocco, because I know that generally speaking, EU fishermen respect EU law, because there are important sanctions under EU law and under domestic law of the EU member states. There are for example, in Spain, there are a lot of sanctions for fishermen who don't respect sustainable consideration in the field of fisheries. So from a sustainable point of view of fisheries, I think that this agreement is highly positive. There are fishing boats there that are flying other flights, not of the EU member state, and they are not so respectful with sustainable fisheries considerations. So for me, it's a very positive issue, and this exchange of letters gives a floor to the interested parties to negotiate, to find a solution to the situation, legal situation of Western Sahara under international law. Yeah.
Mario.
Super, yes, maybe, because we are running out of time, so maybe two quick questions. One I have, and the other one is the one that's been asked on the chat. Maybe I'll start with that one, and then I'll jump in with mine afterwards. So the question that we received is, it says, hello, what is the preliminary process that leads to the negotiation of fisheries partnership agreements? How are specific partner countries chosen?
Okay, thank you for the question. It is very interesting, and it's well. There are different reasons that the European Union is taking into account when it decides to start negotiating with the third countries. There are lots of technical reports regarding where fishing stocks are most valuable. We know that some fish stocks are not so interesting from an economic point of view, and there are other fish stocks which are very interesting from an economic point of view. So depending on the interest, economic interest of these fish stocks, the European Union will start to negotiate such an agreement. It is a long story, and it's a large process. It depends on the economic and political situation of the third country as well. For example, I mentioned the agreement signed with Liberia. Liberia, well, as we know, a few years ago, it was very much prejudiced by Ebola. And the European Union started to negotiate the signature of such an agreement, because it was not such an agreement at that time, with Liberia, in order to help the economy of this country as the consequence of Ebola crisis. Because this partnership agreement, of course, gives the access, give the possibility to EU fishing fleets to fish, to have access to fish stock in those waters. But on the other hand, this agreement offers support for developing the economy of the third country. One part of those funds go to the fishing sectors, and other part goes to the general budget of the country. So the European Union support under this agreement are significant, very significant for many countries. In some countries, it's almost the same, the whole budget of that country. For example, when the European Community at that time signed the first agreement with Morocco, Morocco didn't have an important fishing industry. Nowadays, they are able to introduce fish products into the EU market. So fisheries agreements are very attractive for partner countries as well. So there are different reasons in order to sign such an agreement. I have to say, at the same time, at the beginning of my intervention, I made a difference between public access agreement and private access agreement. A private access agreement is signed with a third country, that doesn't have a fisheries access agreement already signed with the European Union. There are some states, some EU member states, that are not interested that the European Union sign such an agreement, a sustainable fisheries partnership agreement with that country, because they have already important economic interests there. It happens with the Netherlands fishing industry interest, for example, or for example, Spain has very good relations with Namibia. Namibia, the south part of Africa, has important fish stocks in its EEZ, and there are private agreements between Spanish companies and Namibian companies, but there is no a sustainable fisheries partnership agreement signed by the European Union with that country. So there are many and very different interests when the European Union decides to start negotiations with a third country in this field, of course.
Super. Okay, so we are already a bit over time, so maybe I'll just make it very quickly with my question, and then we can wrap it up. If I can just summarize it, I was interested to hear maybe a bit more from you on some of the sort of, let's say, recent developments in terms of sustainable fisheries partnership agreements. And on the one hand, I'm talking about the report. In 2015, there was a report by the European Union Court of Auditors on the sustainability of fisheries partnership agreements. There was a bit critical on a couple of aspects, which are mainly related to data, essentially. So the lack of reliable data that can inform first the definition, the ex-ante definition of the surplus in a third country, and then the sort of the ex-post assessment of the data catch management. And I was interested to know if there was like to what extent the Commission has kind of taken up on some of these recommendations and how it has decided to act upon that. And the other aspect is more related to the essentially to the 2030 Agenda for Sustainable Development and to policy coherence between, on the one hand, of course, Sustainable Development Goal 14, on the other hand, the interest of promoting development as well. And I was kind of curious, even there, to what extent the narrative and the aspiration of the 2030 Agenda has started to kind of creep in the field of sustainable fisheries partnership agreements.
Yeah, thank you very much for your questions. They both are very interesting, and I will try to answer together both of them. I know very well the report published by the Court of Auditors in 2015, and I think that several recommendations of that report have been taken into account by the European Union in the last 3 years, more or less. We have to look at the report where the European Union analyzes each sustainable fisheries partnership agreement. There is a ex-ante and antes and post evaluation of each agreement, and I think information provided by those reports are quite relevant, and they try to take into account the recommendation of the Court of Auditors published in 2015. Regarding the surplus, this is a very sensitive issue because the surplus has to be decided, or the limit of the surplus is decided by the third country. And the third country is a sovereign country. So the European Union is able to use some tools in order to pressure the third country, but finally we are talking about a third country which is a sovereign state, is a sovereign subject under international law. So it is not possible for the European Union to make everything would like to do in this field because it is not entitled to do so. In addition, there are problems in terms of rule of law. We are talking about states that are more delicate in this field, others are stronger. It is on the case, it depends a lot on the case. And of course, in relation to sustainable fisheries, in relation to the agenda for sustainable development, well, the European Union is working with the United Nations in this field and with FAO as well. There is a common agenda. The FAO has established its own priorities in relation to fisheries and goal number 14 of the sustainable goals, sustainable development goals. So the European Union tries to use this agreement in order to develop a security policy in those countries as well. Many times population of those countries don't eat a lot of huge quantity of fish, and fish products are very positive for in terms of diet. So the European Union has as a tools, well, I mentioned only very briefly in one phrase that the Sustainable Fisheries Partnership Agreements are used by the European Union in its policy to fight against IUU fishing, legal, unreported and unregulated fishing. And IUU fishing is one of the issues that are quite relevant for goal number 14. So everything is linked. They have very complex issues, and we have to take into account the limit of the European Union law, of course, but all of the international law as well. So it's difficult to find a balance, but I think these agreements are quite a good tool for many reasons for the sustainability of fisheries stocks.
Perfect.
Just a precision here, because I'm not sure about this point. But this agreement, the Sustainable Fisheries Partnership Agreement, are concluded only by the EU and not by the Member States as well.
No, only by the EU. The English literature would uses signed by the European Union on behalf of its EU member state. I don't agree with this phrase, because these treaties are international treaties signed by the European Union under the Vienna Convention of treaties signed between an international organization and a state. So the international legal responsibility belongs to the European Union. It is an international treaty signed by the European Union, because in this field, EU member states do not have competence. They transfer the competence to the European Union to sign such agreements. So, according to Article 3 and Article 4 of the Treaty on the European Union, we can see that the European Union is entitled to sign international treaty in relation to the conservation of marine biological resources, so fisheries. So the competence is for the European Union, not for the member state. Of course, the member state have the possibility to interfere into the negotiations, because the agreement is signed by the Council, but it is negotiated by the European Commission, and the interest of the EU member state may be represented in many ways during the negotiation process. But finally, the agreement is signed by the European Union, and it is a very interesting, in my view, it's very interesting, the opinion provided by the International Tribunal for the Law of the Sea in 2015 in relation to 4 questions from a regional fishery commission, regional fishery management organization, and the tribunal from Hamburg recognized the shared competence, the shared international responsibility for the European Union and the flag state in relation to activities done by the flag state. As you know, flag state, the jurisdiction of the flag state is applied in relation to fishing activity, and in relation to Sustainable Fisheries Partnership Agreements, the tribunal said that the responsibility belongs to the European Union, because it is an international treaty signed by a legal subject and so on. So the competence belongs to the EU. Yeah. Okay.
Super. Maybe just one last word, just to thank our speaker, Professor Pavoni, if you want to also add something on this front. Otherwise, we can wrap it up for all our viewers.
No, just one word, because we are really, otherwise we are abusing Gabriela's time. Just to say that we are very thankful again to Gabriela, and I think what we all learned is that the Sustainable Fisheries Partnership Agreements are a fundamental tool for the implementation of SDG 14 on the part of the EU, and they are really a strategic tool in that respect. And so we are very thankful for teaching us many aspects relating to this important issue, which of course is just a fragment of the overall action of the EU with respect to the conservation of the oceans. I was thinking about the recent measure taken by the EU to ban single-use plastics. So the fight against the pollution of the seas is also another area where the EU is very much active. But we certainly understood that this is central to the EU efforts towards implementing SDG 14. So thanks again for being with us.
Thank you very much. It was a pleasure, and thank you very much. I'm very thankful to both of you. Thank you very much. Grazie mille.
Perfect. Thank you, Professor Oanta. Thanks again on my behalf as well, and thanks to everyone who participated. We will be in touch on our channels very soon with information about the next few sessions of the EU Law and Sustainable Development webinar series. Have a nice day, everyone.